Hi, good afternoon, everyone. My name is Lauren Ania. I am an elder law and trust and estates attorney with the law firm of Ania, Scanlon, and Sirignano. You are currently watching our weekly Facebook Live seminar series. We've been holding these every week since really the beginning of the stay-at-home order and COVID-19, just as a way to continue to provide you with educational information about estate planning for yourself, elder law planning, and really planning for any age. So today in particular, I'm going to speak about estate planning for the millennial generation and why millennials need a will also. So in case you could not tell from how I look, I am a millennial. I am 29 years old, so I am really smack dab in the middle, really, of the millennial generation. And estate planning is extremely important. Whether or not this is something I do on a daily basis, or if it was something I had no connection to, estate planning for your future is something that every single person at some point in their life will need to do, and it's something that you should do. We live in such a constantly changing environment, society. If the past 3 months have taught us anything, it's how much we do not know and how much we need to plan for the future and for the things that we can control, since there are so many uncertainties. So just before I get into like the really meat and potatoes of this presentation, I want to give you some statistics as to estate planning in general. So as a whole, only about 60% of Americans, 60% of Americans do not have a last will and testament. And 78% of Generation Y, which is the millennial generation, does not have a last will and testament, which means that of millennials, 78% have not done any last will and testament or estate planning, most likely. I had read another statistic where 2 in 5 millennials have a healthcare proxy and power of attorney, which I'm going to discuss a little bit more in this presentation as well. And honestly, I think that might even be a high number. Healthcare proxies, powers of attorney are often not the first thing that comes to mind as what you should do when you enter the workforce or become over the age of 18, but we're going to talk about the importance of that. So just one other topic I want to discuss, before we really dive into what things millennials should be thinking about, is why they should be thinking about this. So one interesting thing that I have read when preparing for this presentation is that 67% of individuals over the age of 50 want to use their wealth to invest in their children and grandchildren, which means that over 50%, so more than a majority of Americans, let's say, want to give assets to younger generations. They want to give us money. They want the millennials to get their money. Great, right? But one major concern these individuals have is that millennials tend to, or they believe we, have a lack of an estate or financial plan. We live in a very different world. We have a lot of student debt. We may be living paycheck to paycheck. We may simply not have any time to really think about an estate plan and why we need one, or meet with an estate planning attorney or financial advisor. But to our older generations, making time to do those things is extremely important to them, to give them the comfort in leaving assets to us and knowing that we will continue their legacies and potentially leave money down to our future generations. So something to think about as to why this may be more important than you think. Another thing to talk about is, well, you may be thinking, I don't really have any money. Why do I need a plan? So most people think they don't need to do any sort of this planning until they have money, until they get an inheritance. But really, the planning often comes first in order to get to where you want to be. So let's talk about it from a financial perspective for a second. If you are waiting for that pot of gold to come into your hands, you're going to be waiting a long time. If you're waiting to go meet with a financial advisor until you have a pot of money to give that financial advisor, again, you may be waiting a long time. One important thing to discuss with your family, your loved ones, or for instance, a financial advisor, is putting a plan in place in order to grow that wealth that you're looking to grow and create that plan that you're looking to have. So, because of these items, because of these statistics, because of the world we live in, I'm going to talk about today what it is that you can do and why you should do it. Why a estate plan is so important for millennials and what really an estate plan is. So one thing that often gets, I guess, misinterpreted is that an estate plan is something for people who have a great deal of wealth. An estate is something you have when you have a lot of wealth, similar to when you live on an estate. So an estate as to a home, land, things like that is very different than what we're talking about when we say estate planning. Estate planning is anything that you do proactively in order to plan for your eventual demise, eventually passing away, or eventual incapacity. If God forbid you were to become incapacitated, if God forbid you had an accident or something occurred where you could no longer handle your own financial or medical affairs. That all falls under the umbrella of estate planning. Tax planning also falls under that umbrella as well, which becomes very important to millennials and any other generation as they accrue wealth. So really, estate planning is something for everyone, whether you have very little assets in your name alone, or if you have quite a bit of assets or will be receiving assets in the future, or if you have no assets. There's certain estate planning documents you will need to have in place so that someone else can handle your decision making, for instance, if God forbid you are unable to do so yourself. So to begin, let's talk about conceptually why there are some reasons, or what the reasons are that you might need an estate plan. So first, let's talk about assets. If you have assets, you should do some sort of estate planning. So what do I mean when I say assets? Well, I mean the income that you're receiving when you go to work and you bring home a paycheck. I'm talking about that savings account that you have in the bank that you put money into and then maybe you draw it out to pay for different expenses. I'm talking about the property that you own. If you own a condo, a co-op, a house, if you own land, anything that you own is an asset. If you own a car, that's an asset. And most millennials have more assets than they think. I know I personally sometimes get pigeonholed when I look at my assets. I look at my checking account and that's all I think about. But sometimes you may have other assets as well. You may have bonds that have yet to mature that you have not yet cashed in. That's an asset. There's money in those bonds. You might have a life insurance policy that you purchased or that someone else had purchased when you were younger. You may have a 401k or IRA. You may have inherited an IRA where you inherited it from a family member who passed away. All of those different assets add up, and they can wind up being and accruing quite a bit of wealth. So make sure when you're thinking about what your assets are, you're not just looking at that account that you're pulling money out from on a monthly basis to pay your expenses, but you're really looking at everything that you own. What's another reason why to talk about estate planning? Well, let's talk about beneficiary designations. So if you have retirement accounts or life insurance policies or anything that has a beneficiary designation, those are assets as well, and you need to be able to indicate who you want to receive those assets. So for instance, if you work for an employer and that employer provides you with certain benefits such as life insurance policy or retirement benefits such as a 401k, when you originally got the job or became eligible for those benefits, you likely had to fill out a beneficiary designation form. So let's say that you got the job when you were 23 years old, you were single, and you put mom and dad down as your beneficiaries, and you put your sibling down as your alternate beneficiaries. And now let's fast forward 10 years. Have you looked at that beneficiary designation form again, or does it still say mom, dad, and your brother or sister? And again, flash forward 10 years, are you now married and have a child? So let's think about that. Do you still want mom, dad, and your sibling to be the beneficiary on that retirement account? Or do you want it to be your spouse? Does your spouse think that they're the beneficiary on that retirement account and you just really haven't taken the steps to look at it? So that's another reason that estate planning is important, making sure that your assets are going to the people you want to receive them. And we're going to talk a little bit more about that when I get into the documents that you can actually use to plan. So another reason, medical issues that could arise. So once you become the age of majority, so once you reach age 18, you're responsible for making your own medical decisions. Mom and dad can't make them for you. You may have remembered when you went to college, you had to sign a specific form in order for your the health center at your college to be able to release medical information to your parents. That's because after age 18, you're an adult. Mom and dad have no authority to receive your medical records or speak to your doctors at that point. And if you don't appoint someone, the only person that can do it is you. So if God forbid something were to happen, you were in the hospital, really no one could make your medical decisions for you. Now there is something called the Family Healthcare Decision Making Act in New York, where essentially it creates a hierarchy as to who would be able to make medical decisions for you if God forbid you could not do so yourself. So for instance, if you are married, it would be your spouse. If you're not married, it might be your parents. But let's say that's not the person you would want to be making those medical decisions for you. Let's say that you're not married, but you have been cohabitating with another individual for 10 years, you're in a committed relationship, you want that person to be making your medical decisions. You need to sign a document that states who you would want to make those medical decisions for you. And that document is called a healthcare proxy. So having a document that states who can make medical decisions is extremely important. Now, with that as well, if you were to become incapacitated, let's say, God forbid, there was a horrible accident, you suffered a traumatic brain injury, and now you can no longer make your own medical decisions. In that situation, in order for someone to make medical decisions for you, a guardian may need to be appointed in order to do so. Guardianship proceedings are extremely expensive. They can be very drawn out. Again, someone who you do not want making decisions for you could be appointed. I like to be in the driver's seat. I like my clients to be in the driver's seat by executing documents that allow you to state what your wishes are if you cannot handle your own medical affairs, puts you in the driver's seat. And this document really states who you would want to handle your medical decisions. So you might appoint your spouse, you might appoint a child of yours, or if you have minor children, you might appoint a brother or sister, and update these documents as you age. But having the documents in place really, really can ensure that your best interest is at the forefront of all decision making, and the person you want to be making those decisions for you is making them. Having conversations with the individuals that you appoint is extremely beneficial. I know that it can sometimes be very difficult to have these conversations with individuals. Who wants to talk about becoming incapacitated, or God forbid what type of things you would want to be done, but having the conversation can be very important. We live in such an unknown world with unknown situations, so having these uncomfortable conversations that could help plan for your future can be very beneficial even from a young age. So another reason is digital assets. So as a millennial, our lives are online. Everything we do is connected to the internet. Even earlier today, my husband, I was paying a bill with a check, and I asked him for a stamp, and he was like, "Lauren, it's 2020, pay your bill online. You don't need a stamp. Everything's online." So even if you're like me and you're fighting it, eventually, and especially through the past couple of months, everything is online. Everything we do is documented on the computer. We have so many passwords. I personally can never keep track of my passwords, so the idea of someone else having to do that for me is terrifying. So keeping track of what your passwords are, if you have solely online bank accounts, or you have electronic assets such as Bitcoin or any other cryptocurrency, making sure that people have the keys or have copies of the keys to that, or have named beneficiaries on that, is very important. We hate to think about the effect that we could one day not be able to do things for ourselves, but planning now for that future is what puts us, again, in the driver's seat. So we have a lot of digital assets. Digital assets can be discussed in estate planning documents, which is another reason why to do your estate plan. So what if you have children? So millennials range in ages of almost 40 to early 20s. So there's a great amount of millennials out there that have minor children. And if you have a minor children, you definitely want to make sure you've executed a last will and testament, healthcare proxy, and power of attorney, which I'm going to talk more about what those documents really say. But if you have children, making sure that you have a guardian appointed for your minor children in a last will and testament is very important. If God forbid you and your spouse were either to pass away, or if you don't have a spouse, if you're a single parent and you God forbid were to pass away, you want to make sure that there is a guardian appointed in a document, so that someone is first in line to care for your child. Again, all of these things put you in the driver's seat. Us as millennials like to be in the driver's seats. We take ownership over our decisions. We want to be the people making our decisions. This is a great way to ensure that you are in the driver's seat making decisions throughout your life from a legal perspective. Not only do we have children, we have a lot of pets. We have fur babies, and they're very important to us as well. So if you are someone who's an animal lover, and you have animals, or you want to make sure that they're well taken care of if God forbid something happened to you, there's things that you can put in your estate plan for your fur babies as well. There's pet trusts that can be written into wills. There's different beneficiary designations that can be done where money can be put aside for a pet and a caretaker can be appointed. So it's something to consider. As millennials, we also want to make a social impact. So a lot of us have charities that are very deep and close to our hearts. We want to make sure that those entities continue to receive funding they need. And if we don't have families yet where we want our money to be going to our heirs, our children, or anything like that, we may want to appoint certain charities to receive our assets. So again, something that you can put in an estate plan. And last but not least is we're really, really busy humans. So millennials as a whole, we're multitaskers, we do a lot of things at the same time. We're very busy, and we often say we're very busy as the excuse as to why we don't do some of these things. Oh, I haven't gotten around to my estate plan. Oh, I haven't even thought about my estate plan. Yeah, I need to go see a financial advisor, but I haven't gotten there yet. So if we take the hour out of our day that it might take to put all of this together and get this done, it will allow us to be proactive, and it'll do our families a favor if God forbid anything ever were to occur to us where everything's already completed, it's in one place, we have a list done, everything is written out as to what our wishes are. They don't have to think about what our wishes might have been. We've given them a roadmap essentially to what our goals are. So let's talk about, okay, now I've told you all of the reasons why you should do something. What is it that you should do? So even though this program is predominantly supposed to be about a last will and testament, and a last will and testament is very important, two especially important documents, two documents that might even be more important than a last will and testament, especially for millennials, are advance directives. And that's your healthcare proxy and power of attorney. So I already spoke about the healthcare proxy, which is a medical advance directive where essentially you are able to appoint someone to make medical decisions for you. It can be a family member. It doesn't need to be a family member. You can appoint a successor agent to make decisions for you. So let's say that you want your brother or sister to make decisions for you, but if they can't, you want someone else to. You can appoint a friend, a mom or dad, anyone else. They can make medical decisions for you if you cannot make them yourself. Very important document to have. Next really important document to have is a power of attorney. Now, a power of attorney is probably the most important document. I'm going to go ahead and say that. And I always tell this story. If you've been on any of my prior chats, I may have already told it. A power of attorney is a financial decision-making directive where essentially you appoint someone to make financial decisions for you. You appoint someone to step into your shoes if, God forbid, you cannot make your own financial decisions. And a few years ago when I got married, my husband and I were about to board the plane, or we had just boarded the plane to go on our honeymoon. And I turned to him and I was like, oh shoot, I never did advance directives. I never did a power of attorney for us before we boarded the plane. And he turned to me and he's like, what are you talking about? Why are you thinking about that right now? And it's because it's so important. If God forbid something happened and we were either, not able to return, or if something happened to us, having a power of attorney that states what our financial decision making is, and gives someone else the authority to handle our financial affairs while we're alive, is such an important document. Again, if you don't have a power of attorney and you have assets in your name alone, no one else can handle those assets for you during your life. Your spouse does not have access to your individual bank accounts. Your parents do not. The only way for them to obtain control over those assets and pay your bills, handle your expenses, handle your digital assets, do anything for you financially is if they have a power of attorney, or if they have been appointed your legal guardian, which would mean a guardianship proceeding would need to be done. Again, these documents are all in the, if God forbid, case of incapacity. And most people, when I say incapacity, think dementia, Alzheimer's, and they say, you know what, that's not something I need to worry about now. I'm young, I'm healthy, nothing's going to happen. But it also comes up if, God forbid, someone has a traumatic brain injury. A few years ago, we had a case where an individual had gotten, unfortunately, in a bar fight, and someone had, I believe, something was thrown, something happened, hit the back of his head, traumatic brain injury occurred, and a guardianship proceeding needed to be done because no one had the authority to handle his financial affairs, and he no longer had capacity. He was a young individual. So I'm not saying any of this to scare anyone. It's just the truth that we do not have a crystal ball. We do not know what's going to happen. And the best way that we can protect ourselves is by pre-planning and having these documents in place. So now I'm going to talk about a last will and testament. So what is a last will and testament? A last will and testament is a document that states where you want your money to go when you pass away, and who you want to handle the distribution of those assets, the paying of your expenses, of your, any of your expenses that are outstanding at the time you pass away, and really where you want your money to go. It does not avoid probate. Probate is the process of getting a will admitted to probate, getting the executor, who is the fiduciary who handles any assets controlled by the will, appointed. It does not avoid that. That's the process that needs to be done in order for someone to actually receive control over your assets. The will first needs to be admitted to probate. It essentially needs to be authenticated by the court, and the executor needs to get letters testamentary in order to act. But the will states what your wishes are. And what it controls is any assets that are in your name alone when you pass away. So if you have a checking account and it's in your name alone, and you were to, God forbid, pass away, no one would have control over that account, and it would be controlled either by your will, if you have one, meaning that the money will go to whoever your named beneficiary is in your will, or if you do not have a will, it would be controlled by the laws of intestacy. So what are the laws of intestacy? That is what, essentially in New York State, it's a New York State statute that governs where money goes if you do not have a will that states where the money's supposed to go. So for instance, if you are a married individual and you have no children, and you do not have a will, if you were to pass away, your money would go to your spouse. If you do not have a spouse, if you are not married, and you do not have any children, your money would go to your parents. If your parents are not alive, it would go to your siblings. If you have a spouse and children, then the money typically gets split between the spouse and the children. So while that may seem like a normal distribution of assets, while that might be where you want your money to go anyways, sometimes that's not the case. Sometimes you may not want your money to go to your parents. Let's say your parents are very elderly and they've done their own planning. And by you having money go to them, in the eventual or God forbid situation that you were to pass away, it would disqualify them for certain planning or benefits that they were trying to either become eligible for or were eligible for. You also might not want it to go to your parents. Let's say that you're not close with your parents or you're not close with your siblings. You may have other individuals or charities or friends who you would want to receive your assets. Same thing with if you have a spouse. Let's say that you have a spouse, but you have tax issues. You may want your assets to be distributed in a particular way, and that can all be written out in a will. or let's say that you have a spouse and children. If you have no will and you have a spouse and children, the money portion of it, a portion of it will go directly to the children. So let's say you have minor children. Now you also need to do a guardianship proceeding for those minor children because they're entitled to a portion of your estate. And let's say you didn't want the money to go to the children at all. You wanted it all to go to your spouse. That needs to be written in a will, because if you have a spouse and children, the spouse is not going to get 100% of your assets. So these are reasons to have a will. Now, again, I'm talking about assets. You might be saying, I don't have assets, Lauren. I don't know what you're talking about. If you have any bank account with any amount of money in it, you have an asset that could be distributed to someone else. You might also receive an inheritance, and then you'll have assets from that inheritance. So having a last will and testament, regardless of how much money you really have, is a very important document to have. It's a wonderful planning tool. It, again, puts you in the driver's seat. All of these documents I'm talking about put you in the driver's seat and give you the opportunity to plan for your future, to sit down, make a plan not only financially for where you want your money to go, but also how much money you want to have. Having these conversations with both an estate planning attorney and a financial advisor can help you meet your goals. Let's say your goal is to, save $100,000 over the next however many years. People can help you do that. So with this information I've given you, where do you start? What should you do now? So some things that I would recommend doing was to first take inventory of what you have. Make a list of what your assets are. Really sit down and think about it. Think about that passbook savings account you have that you never touch, that you have, birthday money in from years past. Think about the cars that you have, your checking accounts, your savings, any stock that you may have inherited, your retirement funds, your life insurance, any digital assets that you own, if you have any family heirlooms that you've been passed down. Also consider what documents you have in place. Have you signed any beneficiary designation forms for life insurance or retirement assets? If so, have you reviewed them recently to make sure that they still state who you want to receive your assets? And also, what documents have you done? Do you have a healthcare proxy? Do you have a power of attorney? If you do have a power of attorney, is it drafted broadly enough to cover all potential issues that may arise? One thing that I see sometimes is you may have a power of attorney that you did when you could not attend a closing for real estate. And it's a very simple power of attorney. It's really for the purposes of handling a real estate transaction, and it does not include all of the necessary provisions that might be needed if one were to become incapacitated. Typically, if someone were to become incapacitated, have a traumatic brain injury, something like that, they might need government funding such as Medicaid to pay for the cost of their medical expenses, their care in home, or God forbid a nursing home. So having a power of attorney that allows your agent to not only move assets out of your name, gift assets away, but also apply for Medicaid and do those types of tasks for you is very important. You may also want to consider where you want to be in 10 to 20 years from a financial perspective, and then sit down with a financial advisor who can help you do that. One of the things I always thought was, okay, I need to have money to give a financial advisor in order to have a financial advisor. And I was kind of wrong in that sense. A lot of financial advisors today have programs for millennials, for individuals who are just starting out and who don't have that pot of money to hand over to them, but want to do something. So these individuals will help you really create a plan. A savings plan will look at what your income is, what your expenses are, and really help you create a plan to get where you want to be in the future, to create that savings plan so that you have something to do in the future. And often they want to make sure you have estate planning documents as well, so that you have a well-rounded financial plan and legal plan, and that from a health perspective, it's a healthy plan as well. So these are things that you can do. They're things that you can do from the comfort of your own home as well. Especially now, you don't even need to go to a financial advisor's office or make an appointment to see them in person. Everything can really be done over Zoom or any other sort of telecommunication conference call. So it's a really great time to sit down while we're not, really traveling. Maybe have a few more hours on the weekends to sit down and review our plans, to schedule an appointment. See what can be done in order to help you plan for your future, and get it done today. Get yourself in the driver's seat. Do something to take control of your future, because, like I said, the world can sometimes be unpredictable. We don't know what will happen, but we do know that we have control over certain things, and our estate planning health, our financial health, and what we do with that is something we do have control over. So I hope that you found this 30-minute presentation helpful. I hope that it taught you a few things that you may not have known, or put into perspective why a healthcare proxy, power of attorney, last will and testament, and an estate plan may be something to consider, even if you are a millennial, even if you are a young individual. So again, my name is Lauren Ania. I am an attorney at the law firm of Ania, Scanlon, and Sirignano. We have offices in White Plains and in Somers, New York. I wholeheartedly believe it is never too early or too late to start planning for your future, and I am available if you have any questions or concerns. My phone number is 914-948-1500, and my email address is l.ania@esslawfirm.com. So thanks again, and have a good day. Stay healthy and safe, and we'll see you all again next week.